All right, kind enough to join us here to break down some of the legal news that's been happening around the former president and the current president. A bunch happening in both spaces. He's the managing partner over at the Parlatore Law Group. Met him recently at CNN, former legal counsel to former President Trump, Timothy Parlatore. Tim joins us here on the podcast. Tim, Mike, and Nick, thank you so much for hopping on with us.
No, of course.
You know, Tim, one of the things that was funny, because a few weeks ago when you and I ran into each other, you said something to me and I was like, save that for the podcast. So here we are. We're going to save it for the podcast. We're finally here. I wanted to first at a high level, because I want to get into a bunch of the legal news happening around the former president and then some stuff that happened last week with the current. But first, for our audience here that may not be familiar with you, maybe they're not news junkies like Nick and I are in terms of consuming all this. You've been on, obviously, the networks talking about what you did for the former president and the defense around the Mar-a-Lago case. Can you kind of explain high level what it is you worked on with the former president?
Sure. So I spent just over a year representing President Trump, and my responsibilities primarily dealt with the investigative phases of both the January 6th and the Mar-a-Lago investigations. I got into it before the special counsel was appointed. So back when it was, the U.S. Attorney for the District of Columbia on the January 6th, and then, the National Security Division on Mar-a-Lago. And then, of course, those all merged under Jack Smith. But yeah, the easiest way to say it is, I was responsible for the exact opposite of, the other side of the Jack Smith
Right.
stuff.
Right. Well, see, it's so much. And that's why I'm glad we have you on, because there's so many moving pieces to all this. And I think people don't understand Florida, Georgia, New York, DC. Like, there's so much to it. So let's start first with kind of where you were sitting with the former president in terms of what you were helping him defend on. There was a recent as we're recording this, so it's happening in parallel. But there was in the Mar-a-Lago trial, there was a discussion on the evidence, a docket that in the Fort Pierce, Florida, there that the former president is in court for as of this taping. Like I said, can you kind of explain what it is that they're maybe potentially looking at here from an evidence perspective in front of Judge Cannon?
Sure. I mean, so right now they have a 2-day hearing on the classified information portion of this case, and so a lot of that stuff is things that obviously you can't talk about publicly. It's one of the complicating factors of a case like this, because when you are alleging that somebody willfully retained national defense information, national defense information is things that, if disclosed, would be damaging to national security. And so that kind of clashes with the idea of having an open courtroom where somebody is presented with the evidence against them, because, they're trying to prove that the evidence shouldn't be disclosed. And so, really they're dealing right now with some of the more technical motions on how to deal with the classified information in that context.
Tim, to that question, though, you just mentioned the logic flaw in presenting evidence that is actually not meant for public consumption.
Correct.
But doesn't the sort of the opposite also then work too? Like, this is compelling enough that the fact that it was still at the residence despite an attempt of retrieval, by the archives department, the fact that it wasn't, at least it's the case, tries to bear out the fact that it was still at the residence. Is that potentially something that the special counsel is trying to present as like evidence in and of itself, even without the jury trying to look at a redacted document?
So it's the difficulty with that is what we're talking about: national defense information. The charge is not withhold or retaining classified information. Classification is just one person's opinion as to what level of national defense information it is. So that there are plenty of things that are classified that are not national defense information. I can give you some examples, from this case on that. And then there have been even situations where there are things that are unclassified that probably should have been classified, that would be considered national defense information. So it really is one of those things that in order to convict somebody, you have to prove to the jury that, how damaging this would have been. So I mean, if you look at the indictment, they talk about how they recovered, hundreds of documents with classification markings, and yet they've only charged, 30 some documents as actually being national defense information. The vast majority of these documents, even though they had classification markings on them, were not national defense information. Things like daily schedules. I'll give you a perfect example. With the schedule that says tomorrow the president is going to fly to Afghanistan to have Thanksgiving dinner with the troops. Highly classified. Really don't want the Taliban to know that the biggest, juiciest target in the world is about to fly over their heads. But the moment he hits the ground and walks out into the dining hall facility with all the cameras, it's no longer national defense information. Everybody knows that he's there. So, there's a lot of things that are like that where very secret at the time, but not so much in retrospect. And so that's really the issue, is how many of these things, really are still national defense information.
It's well said. It's like an FBI special agent that came on the program told us it's not how many, it's what's in it. Right.
Correct.
And that's really what matters. I did want to ask you, and like I said, there's so much. I want to get into like a kind of a summation of all of this towards the end and where you think some of these will net out. We're going to have you put your prognosticator cap on there. But first, let's pivot real quick, because there's been some rulings last week. When you and I met at CNN a few weeks ago, we were circling some dates that would happen on the calendar last week, and there was a couple that were really pivotal. So first, I would love for you to talk about the U.S. Court of Appeals in D.C., the ruling that they had against former President Trump about the president not having immunity. Can you kind of explain what the Court of Appeals ruled on, what case it applies to, and how does this, in terms of a defense argument, like, does this kind of poke holes in what the president is doing? Give us your summation of it.
Sure. So, the argument was whether presidential immunity essentially bars the January 6th prosecution, because all the allegations in the January 6th case are about things that he did while he was president. And it's something that's never really been tested as to what are the limits of a presidential immunity. And in that case, the president's lawyers took the position that everything he does is immune. And of course, Jack Smith took the exact opposite position, that once a president leaves office, nothing is immune. And in that circumstance, I think what the court did was they took the indictment itself and they said, okay, based purely upon the allegations in the indictment, assuming that they're true, that an analysis of these facts, there would be no immunity. And so, and quite frankly, the way that they did the analysis, I think that they're right. I think that they did correctly apply it, because what they did was, the indictment makes very clear that he was doing these things allegedly in his capacity as candidate Trump as opposed to President Trump. And that's always been kind of one of the difficult points that we were looking at, is that so many of these things, just if you change the perspective ever so slightly, it puts everything into a very different light. So on one hand, you go with the way that Jack Smith has done it, and you see it in the media all the time, that candidate Trump was trying to overthrow the will of the people and have himself installed. If you change the perspective just ever so slightly on that, and you say that, okay, maybe he didn't know that he lost. Maybe he did believe that he won. Maybe he did believe that there was fraud that wasn't being properly investigated. As President Trump, somebody who under the Constitution is mandated to ensure that the laws of the United States are faithfully executed, does he have an obligation to pressure the Attorney General and law enforcement to make sure that the will of the people was accurately counted? And so that slight change in angle really makes all the difference here, because if he was really just trying to push to ensure that the will of the people was accurately counted, and he was trying to avoid certification of a inaccurate counting, then that could potentially be within his role as the chief executive and therefore subject to privilege or immunity. Whereas as a candidate trying to overthrow the will of the people, there's nothing that could possibly be considered legal or immune about that. And the difficult thing that the appellate court had to deal with was that this was all done without the benefit of a pretrial hearing. So they didn't have an evidentiary hearing to really test any of this whatsoever. Now, there's a couple of ways you could have done it. You could have done it with a pretrial evidentiary hearing, or you could wait until after the trial is over and say, what was the evidence that came out at trial, and does that show that immunity should have applied? And so, I think that that's probably, if I were them, that would be the points that I would be hitting to the Supreme Court right now and say, yeah, hey, they made this decision based on this, but maybe an evidentiary hearing should be held first. And either way, that ruling, while it certainly says that the prosecution can proceed at this stage, it doesn't preclude a potential argument after trial that the evidence that came out differed from what the indictment claimed, and therefore immunity could apply.
I'll be honest, Tim, as you mentioned that, I'm a loss too. I'm not a legal expert, obviously, but this seems a little like we're sort of trying to figure out what was the initial interpretation of these laws versus in the practical world, where do we fall into? And the parallel I'm going to draw here is what's going on in Colorado.
Yeah.
From what it seems to be is that we're talking about a 14th Amendment with a particular section, in this case, I think it's Section 3, that doesn't quite name the president as a role for someone to be mindful of potentially being ineligible to run for office while being involved in, potentially insurrection. You're going to correct me all on this in a minute, but is that what we're dealing with here? That there's just a lack of clarity from the founders or those who've written all these legal documents that leaves this kind of room? And if so, is that just a case that it was just never imagined we'd be in this situation, or was there some intentionality of leaving some room for interpretation so that lawyers nowadays or in the future can continue to try to make sense of this?
Well, and that's you're hitting it right on the head there, because yes, there's always vagueness in these things. I mean, you can make very clear laws, but those then run up against facts where there are factual situations that are much more gray. And I think that in the 14th Amendment context, certainly you are running into a situation where it doesn't name the president or the vice president. You know why? Because nobody was even thinking about that, because Abraham Lincoln did not join the Confederacy. It doesn't clearly define what an insurrection is, because the name, the understanding of what an insurrection is was very, very clear at the time. It was, you put on a gray coat, you trade in the stars and stripes for the stars and bars, you pick up a rifle and you start shooting at guys wearing blue coats. That's a very simple definition of insurrection. So nobody really questioned if you were a member of the Confederacy. It excludes the vice president too. And interestingly, if you look, the vice president at the time, Andrew Johnson, he was a former senator from the state of Tennessee. And when Tennessee joined the Confederacy, he broke with his own state and he remained loyal to the Union. And so, those are some of the reasons why when they wrote the 14th Amendment, they didn't need to add those positions. The flip side of it is, Justice Jackson, raised some very good points there, where she was saying, isn't this different because these are national positions? We're afraid of the South rising again, and so we don't want to have congressmen and senators from these states where you will have a Confederate congressman from a deep South state. But when it comes to the president and the vice president, that's a national election, and so a small insurrectionist state in the South can't dictate who the president's going to be, because the North gets a say. So that's another possible reason why they did that. But you're right. It's one of the reasons why, if everything was so clear and not open to interpretation, I would be totally out of work. My profession wouldn't exist. It'd be very simple.
Right. And we'd be out of work too, because we'd have nothing to talk about here. I mean, quick break from our pod to tell you about a new pod at Fresh Roasted Coffee, Envy Pods. So if you go to freshroastedcoffee.com, my partner's shaking his head. That's a good transition. Are you kidding me?
It was good. No, I shook my head. I was like, that's brilliant.
Thank you. Thank you.
Because I saw this picture earlier. I was like, I saw what you're doing.
It is pretty good. That's right. So listen, the new Envy Pods over at freshroastedcoffee.com, the official sponsor of Can We Please Talk, environmentally safe, compostable. You can go check these out at freshroastedcoffee.com. When you open up the package, it smells delicious. I'm telling you, you can't smell it on here, but I promise you that when I opened this morning to make my cup of coffee, it was delicious. Head to freshroastedcoffee.com today. Use the promo code CANWEGET20 for 20% off your first order or hit the link in our show details. But Tim, you're doing a great job because, like I said, there's so much to this, and I feel like voters are truly not understanding it. And it's what I love about what Nick and I do, not to toot our own horn, but podcast format is better to kind of explain and get a little bit more in the weeds. So I did want to ask you, as you were mentioning all of that, and obviously we know the former president, excuse me, has been traveling to a bunch of these places, with the Georgia RICO case, with what's happening in New York. He had a civil trial. Now he's potentially with Alvin Bragg's case, whatever happens with that. He's in Fort Pierce, Florida for this. I want to ask you kind of a two-parter here. First, did you, when you were serving on his legal team, did you guys have any communications, or were you looking at like a calendar holistically to say, look, we may be up against this in terms of a date wise, where he could have a conflict. Our client would have to travel to and from different states. Kind of give us the background of what that looks like, what that war room kind of looks like. And then the second part of this is, where do you see some of this stuff shaking out? Because every television segment always ends with a look at the political calendar and his legal calendar. But nobody has been able to really kind of outline or articulate, I feel like you do, of where they actually see it shaking out, because they weren't in on the inside, right? Where you actually were making a projection. So kind of give us the insight of what it was like working under him and the coordination between some of the legal teams, if there was any. And then on the flip side, where do you see some of this stuff shaking out before November?
Well, so the answer to your first part of the question is actually very simple, because I left the team about a month before the indictments came down. So we were not really looking at the schedule because, quite frankly, I mean, my goal at the time was to make there be no indictment. We were trying to convince Merrick Garland not to pursue these things. And so trial calendar was something that was, very far outside the scope of my view at the time. As to like, where do I see it shaking out now? One of the interesting things here, I try a lot of cases, some of which are, pretty politically sensitive, but none that involve an active candidate. That's kind of a very unique situation they have right here, because usually when somebody gets indicted, they drop out, or they're in a jurisdiction where they have, so much support that reelection is not really as big of an issue. Like, Senator Menendez. So, having that calendar is a very unique thing. And, I know that everybody kind of looks at it as, oh, he's trying to delay it and he's trying to push it out past the election. But I look at it as, I have never had a federal criminal case this complex with this volume of documents that ever comes close to a trial date within 2 years. It just doesn't happen. I have a case right now where the number of documents, the sheer number of documents, is on par with the January 6th case. That was indicted back in 2018. We still haven't gotten to trial. Okay? So the idea that you can take a case with over 1 million documents in discovery and pick a jury in under 12 months is crazy to me. It goes directly against, all of what we do in federal criminal defense. And so, Jack Smith is really, pushing these things to get them done before the election in derogation of how these cases normally go, and then turning around and saying, look, he's trying to delay it. And so, and look, I would be saying the exact same thing if you ask me, are they trying to delay the Hunter Biden trial past the election? Yeah, same thing. These cases, they just don't go that fast. There have been very few instances. I've had 2 cases where I've, pushed for it to go that fast. And both times it was, relatively simple cases. And all of a sudden I got up and I said, okay, my client invokes his right to speedy trial. We want to, we want to pick a jury in the next 2 months. Prosecutors fell apart and dismissed the cases in those situations. So it's not realistic to try any of these cases that quickly.
I appreciate the reference to, well, I'm originally from New Jersey, so Gold Bars Menendez is someone that's definitely part of the chatter, for my fine folks in the Garden State. Tim, as we're
I'm
talking,
originally from New Jersey too, actually.
what's
So
that?
I'm originally from New Jersey as well.
We can't be blamed for Senator Menendez. Um, Tim, as we're talking about the former president, I guess I'll ask this as plainly as possible.
Mhm.
Oftentimes, it doesn't seem like he's aware or understands the ramifications of public sentiment in a case where it seems like ideally you'd want to defer to your lawyers for messaging. Am I misreading that, or is Trump really of the belief that the more he can be able to basically put forward his view in a public space like in social media, the more that may potentially work to his benefit, even though he may potentially be putting forth information that for his legal team, of which you once were a part of, may actually make your jobs harder?
It's a unique situation. Look, I got along well with my former client. And this is not a political statement. This is just a personal statement. I got along well with him. I never had an issue with him. The problem is the people that he is surrounded with. And every other person that I've ever represented that's had a campaign, the representation has always started out the same way. They'd introduce me to the campaign and they'd say, look, you guys, you're here to get me reelected. Tim, you're here to keep me out of trouble. You guys, stay the hell out of his way. Tim, anything you need, you give it to him. And that was it. It was very clear lines from the beginning. Here, he has the campaign, he's got, the legal, and one of the things, I am not a campaign guy. I refuse to take part in any of that stuff. For either party. I'm just, I don't fit into either party. I'm nonpartisan, to an extent, and so I don't, I didn't participate in that. All I'm focusing on is, should my client go to jail? Whether he should go back to the Oval Office is somebody else's issue. And, so when you do have that, you do have competing interests. And one of the unfortunate things is when you have people like this, you have competing interests of people that all feel like their opinions mean something. And so, in an ideal world, you focus just on the case in front of you and you don't have to deal with these other things. Then you wouldn't have all these issues with the calendar. You wouldn't have the issues with the public statements. You wouldn't have the issues with the competing cases. All of this would be far simpler if you were able to strip out all the election stuff and just focus on the facts, evidence, and the law and what does justice require.
Tim,
I know
welcome.
that's not a direct answer to your question, but that's as close as I can come.
I am compelled to ask you a follow-up to that, though,
Sure.
Tim.
Yes.
So what you're just alluding to, if I heard you correctly, is that the candidate, aside for a minute, can surround himself with some problematic people that can make a person like you have a harder time doing your job. Is that safe to say?
Yes.
He wins the election. How concerned are you about those kinds of people possibly being involved in policymaking?
That is a political question, which is, as a
Fair
lawyer,
enough.
I'm staying out of.
See? Welcome to radical. That's a good lawyer answer, by the way, right
No,
there.
it's fair, but I am compelled to ask because I mean
it's a good question. I don't blame you for asking the question, but like I said, I'm a lawyer, not a politician, and I don't want to even touch that.
Well, welcome to radical centralism, if that's a term here. We just coined it on Can We Please Talk. Tim, I did want to ask.
Ben Franklin used to say, I'm an extreme moderate.
Oh, I like that. I might have to take that. Oh, on the masthead here of the show, Nick.
Franklin never gets enough credit. That's that's the political.
I did want to ask you real quick about something I was mentioning to you before, because I want to shift to the current president and special counsel in his case of mishandling of classified documents. A little bit different, obviously, in terms of the cooperation, but there was some damning stuff that came out of there. And then on Meet the Press this past Sunday, speaking of a political show, his co-chair, Biden's co-chair for his reelection campaign, Mitch Landrieu, was asked a question from Kristen Welker, the host of Meet the Press. I want to play the clip for you here because I kind of want you to react, because it kind of intertwines between what you were mentioning in terms of campaign versus the legal analysis and legal beagle. So take a listen to this. We're going to react on the other side.
And just to be very clear, the report didn't say he wasn't engaged in any wrongdoing. In fact, it was quite firm in the fact that he mishandled classified documents. He just wasn't indicted and criminally charged. But let me follow up with you. The documents found in the president's
no, Krista, wait. Let me. No. You can't. No. I'm not gonna accept that premise. In an investigation, a special counsel determines based on the facts and the law about whether somebody engaged in criminal wrongdoing. And he found out that the president did. And as a matter of fact, he's the only special counsel that's been engaged in this kind of activity that had to say that he could not indict somebody. And that is a fact. And so that's the big takeaway from this report from a legal perspective.
All right, Tim, is that the big legal takeaway from all of this? Because this kind of made news, and obviously the current president, these Freudian slips are killing me, Tim, but the current president gave a presser.
President of Mexico, you mean?
Right, president. Exactly. Right. So you know what's happening here. So he comes out after the special counsel gives, a little bit of, the summation of, the findings from the report, but then no charges. Give us a little bit of a breakdown of what happened there, and then what Biden's co-chair there said. Is he accurate? Is that the major takeaway from this report from Special Counsel Hur?
So, one thing to remember is, investigators, they do their investigations, they come up with their, conclusions, but there's no due process in that. Okay. This is a prosecutor who has conducted investigation, and they come up with, what the allegations are that have to be actually proven in court. So any special counsel or inspector general, anybody that comes out with a report saying somebody did do this, that's not proven as of yet. And I would, I'd say that about anybody, whether, the current president, former president. The evidence in this case appears very damning. It does appear, that he did, engage in the willful retention. And I think that the special counsel did a pretty good job of, kind of analyzing how does this go to trial? Okay, because ultimately investigators, like the FBI, they'll go through and they'll say, we think this person did this. The prosecutor has to then take it the next step and say, okay, that's great. That's certainly enough, to arrest somebody. Is it enough to win at trial? Can I convince a jury of 12 people beyond a reasonable doubt that they did it? And so you have to consider potential defenses. And, here he obviously, laid heavy on the defense of, mental incapacity, that the jury may believe that he didn't intend because he didn't know, because he forgot. I'll tell you the thing that really jumped out at me about this report is I went back to to my own work in the Mar-a-Lago case, and we had written a letter to the House and Senate Intel committees, right towards the end, right before I left, where we did a deep analysis of how these documents got out of the White House to begin with. And we wrote it in a way that was applicable to President Trump, President Biden, and Vice President Pence. Because the reality is, what this case shows beyond a shadow of a doubt, what the Trump case shows beyond a shadow of a doubt, is that the White House does not have proper document handling procedures. They do not follow the same procedures that the Department of Defense follows, that the intelligence community follows. And so the reason why these documents left government control to begin with is because of a failure of document handling procedures within that institution. I would say that based on reading that report, it appears to me the documents got to Mar-a-Lago because of carelessness, because it was a rushed transition and GSA packed everything up real quick and moved them down. They didn't have any place to put them other than Mar-a-Lago. And so there's no allegation that anybody said, hey, I want to take all those classified documents with me. All of the litigation that they're going over right now is based on what happened down there once the documents were found. Now, Rob Hur has taken it a little bit back and said, some of this may be that, but also some of these, like the notebooks, were things that his staff specifically told him, you can't take this, but it wasn't clear. And so he was allowed to take them anyway, which again is the type of thing that you would not expect coming out of the Pentagon or CIA headquarters or anything like that. Although David Petraeus was in fact charged and convicted for doing exactly that. So it does go back to the point that we were making at the time before the Mar-a-Lago charges came down, that the way to resolve all of these cases is by the legislature going in and creating a solution of fixing the procedures within the White House. They have actual knowledge of a national security threat, of an actual national security vulnerability that can be fixed. Focus on that instead of putting, former or current occupants of the White House in jail. And if you look back in history, Presidential Records Act was passed during the Carter administration. It first applied to President Reagan. Every single president, from Reagan up through the present, they have found a mixture of classified and unclassified documents in the boxes after they left office. Every single one. They found documents in Joe Biden's house. They found documents in Mike Pence's house. They're too afraid to go look at Dick Cheney's house. This is a problem and one that can be fixed. Jimmy Carter found documents in his house. Presidential Records Act didn't apply to Jimmy Carter. He found them and he called the National Archives and said, hey, you want to come get these? Over 40 years we've known about this problem. Over 40 years. And so then you look at when the transition happened and President Trump, they have all these boxes out on the driveway and the National Archive director is saying, oh, well, I was very concerned seeing that on TV because I thought, those records should go to the National Archives. No, he knew that there were classified documents in those boxes. He didn't say anything. He let them go down to Mar-a-Lago. For the next year, when they're going back and forth saying, oh, these are Presidential Records Act documents, they should be brought back. He never once says, Mr. President, by the way, I think that there's classified documents in your basement. Can I send somebody down there to go through them and just make sure that we've safeguarded classified information? Never once. Instead, they waited until the first set of boxes came back, find that it's the exact same mixture of documents. And by the way, I went to the National Archives. I went through these boxes myself. They went through and they found it's the exact same mixture of documents that they've had in every single administration up to that point. And they, run off to DOJ saying, oh my God, he's got classified documents in his house. It's exactly the same thing that they've had for every other administration. Joe Biden, when they started finding documents in his house, he had the benefit of seeing what happened in Mar-a-Lago. He had seen the FBI raid Mar-a-Lago. And if I was his lawyer at the time, I would have sat down with him. I would have said, hey, look, dude, here's what we got to do. You see what happened in Mar-a-Lago? We are going to make a huge show of being different from that. We're going to make a big drama about how, compliant and helpful we are so that at the end, you can make this speech saying, look how compliant I was versus the other guy. So, I mean, that to me was something that was, really choreographed from the beginning by some very smart lawyers. I give them a lot of credit for that. I think they did a good job. But ultimately, at the end of the day, how you respond once you're under investigation doesn't mitigate the original act. The crime, if there is a crime in this case, is committed when the documents are removed intentionally, if they are, when they're retained after you find them, if they were, and not how nice you were to the investigators once they reach out to you.
That's why we have you on. That's why we have subject matter experts, people that have been around this stuff, have worked in it, have worked on it, have covered it, are covering it. Tim, I can't thank you enough for hopping on the podcast with us and giving us a couple minutes. Continued success to you, sir, and please stay safe.
All right. Thank you.
Hey, thanks for watching the Can We Please Talk podcast. Whatever clip you just watched, we hope you enjoyed it, and we hope you stick around for some more. Subscribe to the channel. My partner's over here smashing the button. Come on, do him a favor. So hit subscribe.